Everybody hear me?
Yes.
Good morning, everyone. The 357 District Court will call its court into session for today's docket hearing Tuesday, February 22nd, 2022. Starting with civil hearing, 2021 DCL 6031, Margarito de la Fuente. This is a declaratory civil judgment. Margarito de la Fuente. Present. 2021 DCL 1461, American Express versus Mayville Constant.
Plaintiff's counsel is here, Your Honor, on behalf of American Express National Bank.
Mayville Constant. Hello? Is there a Mayville Constant on the line? All right, proceed, Mr. Spence.
Okay, great. This is just a basic credit card case. Mabel Constant applied for a credit card. We issued one and they used it and subsequently defaulted. As evidence of that, we submitted with our motion for default judgment exhibit 1, which would be the business records affidavit from our assistant custodian of records, as well as exhibits A and B, which are the card member agreement and the most recent payment statement. We also submitted the certificate of last known address as well as the SCRA affidavit showing they are currently not enlisted in the military. Mabel Constant was served on the 17th of March, 2021. Based on that, I would ask the court to take judicial notice of all our exhibits and award the amount of $10,206.45 plus the cost of the court, no attorney's fees and no interest.
All right. The court having called out the name of Mabel Constant, no answer having been had. The court will take judicial notice of all documents and file, including all exhibits tendered to the court for its evidence for the default judgment. The court hereby grants the default judgment prayed for in the amount stated on the record.
Great. That should be a judgment of excuse.
Yes, sir. Thank
Sir,
you.
take care.
Here's one, I will sign it. All right. 2021 DCL 4824, William John Smith and Caroline Smith. Mr. Salazar.
Morning, Judge. Miguel Salazar here for Mr. Smith.
All right, Caroline Smith. All right, what's going on this one?
Judge, the petition was filed last year. It is right for final hearing. Respondent has not filed an answer. We wish to proceed with a default judgment.
Okay. All right, proceed.
Mr. Smith, can you please state your name for the record?
Second.
Mr. Smith, can you please raise your right hand?
Apologies.
Your right hand. Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can put your hand down.
Mr. Smith, can you please state your name for the record?
Yes. William John Smith, Jr.
And you're currently married to Carolina Smith?
Yes.
And have you been a resident of this state for the preceding 6-month period and a resident of this county for the preceding 90-day period?
Yes.
And were you married on or about September 2019 and ceased to live together as husband and wife on or about August of 2021?
Yes.
And has the marriage become insupportable because of discord and conflict of personalities that destroys the legitimate ends of the marriage relationship?
Yes.
And were there any children born to the marriage?
No.
Were any children adopted or are any children expected?
No.
And is your contention that there was no community property accumulated during the marriage?
Yes.
But to be specific, you are asking the court to grant any property under your possession and control as any property and debt under your possession and control as your sole and separate property?
Yeah, I am.
And specifically, you're asking the court to award Lot 23, Block 1 of Olmito Estate Subdivision, Phase 2, Cameron County, Texas, as your sole and separate property?
Yes.
And you're asking the court to grant any property and debt under your wife's possession and control as her sole and separate property?
Yeah.
And you're asking the court to grant this divorce as stated?
Yes.
All right.
Nothing further.
Can I ask a clarifying question on the what's the background on this property?
The property, Judge, was bought in 2019 with separate funds from Mr. Smith. He's been the one paying for the property. There has been no enhancements on the property since it was purchased. So even if Ms. Williams were here to try to contest anything, Mr. Smith would argue that that was separate property to begin with.
So you acquired that property before you married her, Mr. Smith?
Yes,
Okay. And you're saying you're still paying on that property? You still owe money on that property?
yes, sir.
Okay. All right, the court will take additional notice of all documents and file. The court will find that it has jurisdiction by virtue of the domiciliary requirements of the family code. The court having heard the evidence, the call, the name of Caroline and Smith, no answer having been had. Court further having heard the evidence from petitioner William John Smith regarding the matters of and the jurisdiction for the divorce. Court hereby grants the divorce as pray for it, order the division of the assets debt as stated on the record. Anything else?
Nothing further, Your Honor.
All right, do you have a decree, Mr. Salazar?
Your Honor, we do not have it ready because we weren't sure if the respondent was going to show up, but we will have it ready for you as soon as possible.
Thank you. Thank you. Thank you, Mr. Smith, for being here.
Okay, thank you.
Thank you, Your Honor.
All right, Mr. Villarreal, 2022 DCL 730, the matter of Jose Eduardo Flores and Luis Alberto Espinosa.
Good morning, Judge. How are you today?
Morning, how are you?
Doing well, thank you. This is a protective order application that was submitted. We've not been able to serve the respondent, but I believe that's him on the screen on the window that says Moto G Power.
Can you unmute yourself, sir?
Excuse me, Your Honor. That's not him. That's my client. We're waiting for the criminal docket.
Okay,
My apologies, Judge.
that's all right.
Well, since we've been unable to serve him, I don't know that he's appeared. I think we're going to need an extension so we can do substitute service on him.
Okay, will you let me know? How long do you need?
Well, we can extend this for 14 days and extend the existing ex parte temporary order, Your Honor.
All right, that will be ordered. All
Okay,
right.
Judge.
Ms. Salas, give me the 14 days from now. 13th day, actually.
They set it up for the 7th of March.
March 7th. Thank you, Judge. That's all I have in your court this morning. May I be excused?
Mr. Villarreal,
Yes, sir.
I'm glad to see that you're not after my coveted award.
Well, I was going to make a comment, Judge, and since you've gone there,
You're here on time, Mr. Villarreal, so you're not after my coveted.
is it weird that everywhere I go, I feel like you're watching me, sir? I see your face everywhere.
Yes, we're all looking at you, Art.
Thank you.
Come on, Mr. Villarreal, come on.
May my client and I now be excused, Your Honor.
Yes.
All right. Y'all have a good day, everybody.
You too.
2022 DCL 730, Jose Eduardo Flores. Oh, we did that one. 14 days.
Mhm.
Criminals till 9.
Criminals till 9.
Estela or Ms. Carranza,
Yes,
can we log out and come back in at 9? Or are we gonna
Yes.
start anytime? Or are we gonna start sooner than that?
no, the jail starts at 9.
All right, okay, we'll log back in.
Okay.
Thanks.
Ms. Salas,
Yes, sir.
when are you gonna come back?
But you tell me, I'll go back
No,
whenever.
No, ma'am, I've been waiting on you to exercise your judgment. You're the one that, because of fear and I agreed, but when do you think you wanna come back?
Oh, I can go back anytime.
Huh?
I can go back anytime, Judge.
Well, I'm being waiting on you to tell me, that you're ready to come back. I agree with what you were doing and I don't have any problem with that. But
Okay,
I was waiting for you to tell me, I'll be back, whatever, and I said, okay,
Yeah. I can go back tomorrow, Judge.
it's up to you. I'm not pushing you to come back. I want you to tell me.
Yeah, are we working okay with while we're doing it? Are you okay with everything?
Yeah, so far it hasn't been disruptive. It's worked fine.
That's good. That's good. That's my main
But
concern.
we know that this is an option for us if this thing again gets
Yeah.
crazy.
Yes.
So,
Yeah, I can go back tomorrow, Judge. Good morning, 257th.
All right, Mr. Salazar,
Yes, Judge. Morning again.
line on?
Yeah, yes, he's on.
Raise your right hand, sir. Mr. Ponce. Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can put your hand up.
All right. Mr. Salazar,
Yes, Your Honor.
who's the probation officer? Mr. Garcia? Good morning.
Morning, Judge.
Morning. What are we doing with Mr. Ponce? From the probation perspective, it looked like he was straightening out and then he failed to report completely. Is that what it was?
That's correct, Your Honor. This is the third time he appeared before the honorable court, Your Honor, and it seems like every time he starts off, for the most part, well, and he makes an effort to comply, but every time he comes to a bump on the road, Your Honor, he ends up absconding, Your Honor, and he did it again this time. He did it the previous time when the court granted him safety, and he ended up leaving the transitional phase of safety. He absconded. We brought him back. They gave him another opportunity. We put him on surveillance, Your Honor. He was doing, for the most part, he was doing well. He was making payments. He was making an effort. He was allowed to come and go in and out of the county because he was working for a company, I think it's called Advantage Solutions. They are, they set up Home Depot stores and whatnot, Your Honor. And all of a sudden he could not make it back. He would not report. I was trying to reassign the case, Your Honor, actually to regular probation when he stopped reporting. And so that's what we have right now, Your Honor.
Wow, I don't get it. I don't understand that.
Judge, if I may.
Yes.
So obviously, Mr. Ponce is, acknowledging his shortcomings. And there's, a part of the reason is just him slightly confused as far as how things were supposed to go. He was under the impression that he was going to be able to pay for the community service hours, but no, he didn't get clear direction as to how to do that. Mr.
Well,
Ponce.
I'm not concerned about that. I'm concerned about his failure, just dropping out. Dropping out, not reporting anymore. I'm not concerned about the community hours. I mean, he's drowning in a glass of water if that's what he's concerned about. I'm concerned more about he's dropping out and not reporting, and he has done that twice.
Yeah.
Twice. He runs to the non-reporting resort for some reason or another, and he blows it. He's blown it before. I have not revoked him. I have given him many opportunities. I've kept him out in the hopes that he would straighten out, do right by me by reporting to probation as he promised me a long time ago. But he finds it hard to do that at certain points in his life. And I don't understand why. Even a phone to say I'm alive, I haven't gone by, offer some excuse. Just dead crickets. Nothing heard from him, just not reporting anymore.
Yes, Your Honor, and as stated, he recognizes that he
For
should
him
have
to,
been.
hold on, I haven't finished. For him to say that he didn't understand something, was confused about something, that's disingenuous on his part. Because the probation officer is certainly present. He's communicated with him before he stopped reporting. He could have easily picked up the phone, called his probation officer to get some clarification on any confusion he may have. Didn't resort to that, but resorted to self-help and to get on the land. So I don't see how those coincide at all. And I don't find that to be an appropriate excuse that he was confused by anything that was required of him. So,
Judge, and he knows that he needed to be more persistent. He recognizes that now. Part of the reason is,
well, they always do when they're at the precipice of getting revoked and getting punished.
and Your Honor,
They get enlightened, all of a sudden a light turns on their head that this is trouble, big trouble for them, which we've tried to avoid through this whole process of me extending and modifying and putting up with a lot of his inconsistent behavior on probation. He's the first one to say that I have given him a lot of opportunity to straighten this boat out.
yes, Your Honor, and he's been,
over backwards for him to try to get him on the straight and narrow.
Judge, and he's been wanting to get his, a hearing on this MTA for quite a while now, which is why he asked me to step in. I just recently stepped in on this case.
Well, I'll give you an opportunity because I'm not very happy about how this thing has evolved after so many opportunities that I've given him. For it to have to come to this again, there's a point where this court has had enough. It's had enough. I gave Mr. Ponce the fate of his own life in his own hand, not once, not twice, but 3 times. And 3 times he's throwing it back at me. I want to get off this merry-go-round. I'm not playing this game anymore. All right. So if you need some opportunity, I will give you that full-blown opportunity to defend himself. He doesn't have to be true to any of this. So you tell me when you want to do this.
Judge, if the court would be willing to do that, he's ready to plead his case today, Judge. We do have, I strongly feel that Mr. Ponce does have the merits to stay on the court's good graces. He understands that there'll be no further opportunities. Mr. Ponce right now is doing
that either. I already went. There'll be the 4th time. Nothing will change from my warnings to him that if he fails me this time, it's gonna go, because I've already given it to him 3 times, and 3 times he's blown me off. So it's very difficult for me to hear any of this, any of his excuses, anything that's gonna come out of his mouth. He knew exactly what I needed from him. He knew what I wanted. He knew what he needed to do. He was given every consideration I could possibly give anybody accused of this kind of crime. It's a serious crime, a robbery. And I gave him an opportunity to put that behind him. And he continues to live it, continues to be involved in it, because he won't complete his probation as somebody that was in serious trouble to begin with.
I understand that, Judge. Judge,
do you want any more opportunity to prepare yourself for this defense, whatever it may be?
Judge, I think it is, I suppose, in the best interest to try to explain ourselves today and not allow more time to go by. Mr. Ponce is more than willing to speak to the court and explain himself personally. And again, Judge, I mean, right now he's doing great at his.
The problem is that I don't, unless it's in the form of a defense to each one of these items, then I want to take them like a trial, correctly, one by one. And if he's going to testify that none of them is true, that it is all not true, then we're going to do that. So you're going to have to wait for me until I get rid of the rest of the docket so I can give you all the time necessary for us to go one by one. And he can give me all his proof, because he's got to remember, and I told him this, that when you're on probation, I don't have to find all the allegations to be true. I just have to find one of them. And that's enough for me to send him to the penitentiary. So you tell me which allegations he's pleading not true to, and we will certainly hear him on that. So I'm going to go one by one. The allegations contained in the state's motion to adjudicate, and whatever he tells me it's not true, those are the ones that I want to hear proof of to the contrary. All right.
Judge, if we may then, could we possibly get a reset on this to fully prepare on each
Well,
part
that's
of
what
the
I'm asking you to do. I mean, I'm suggesting that you do that so you can be fully, and for Mr. Ponce to have a full opportunity to put forth any defense he may have to any of these allegations. I certainly will give you that opportunity.
We appreciate that.
How long do you need?
Uh, no more than 30 days, really less than that, if possible.
Ms. Salas,
Let's set it up for March 22nd.
March 22nd. At that time, we will have a hearing on this motion to adjudicate.
And that's at 8 a.m., Judge?
I'm sorry?
That's at 8 a.m.?
Yes, sir.
Thank you, Judge. We'll be ready for that hearing.
In the meantime, I will hope that Mr. Ponce does the right thing and not commit another crime or get into any other problems. Thank you.
Definitely. That's all I have with the court. May I be excused?
Yes, sir.
Thank you.
Be excused.
Your Honor, I have nothing else. May I be excused, Your Honor?
Come again?
I have nothing else, Your Honor. May I be excused?
Yes, sir.
Have a wonderful day, Your Honor.
You too.
Carizales, who do you have there?
This is docket number 7, Espinosa.
Okay, thank you.
Yes, ma'am.
Mr. Galarza, are you on?
Morning, yes, I am.
Mr. Galarza,
Good morning, Judge. How you doing?
do you have by any chance a grandmother on this feed?
Your Honor, I don't have her here.
I'd like to have her on the thing before I make it.
What I can do is I can go ahead and call her right now.
Yeah, if you can give her the information for her to get on Zoom, I'd like her to be present.
Let me get in contact with her right now, Judge.
Thank you.
Thank you.
All right,
You want to call the other, we have to call the females first, Judge. Do you want to call the other female right now?
who is that, Patricia?
Yes, Patricia Ramirez. Carizales, you have Ms. Ramirez, please.
Yes.
Thank you so much. Raise your right hand, ma'am. Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hand down.
Thank you.
Morning, Judge.
Morning. All right, this is cause number 2012 DCR 1127, State of Patricia Sanz Ramirez. Is that the true and correct name, ma'am?
Yes, sir. Yes, Your Honor.
Are you the same Patricia Ann Ramirez, Patricia Sanz Ramirez that on September 24, 2012 pled guilty to or driving while intoxicated third or more felony and was assessed a confinement period of 8 years in the penitentiary, and that term was suspended for 8 years and you were placed on probation for 8 years. Is that you?
Yes, Your Honor.
You're represented by Mr. De La Garza here this morning, is that correct?
Yes, Your Honor.
Mr. De La Garza, do you waive formal reading of the state's motion to revoke Ms. Ramirez's probated sentence?
We do, Judge.
Do you find Ms. Ramirez competent and able to assist you in any defenses that she may
She has
have?
been.
No matter.
I did find her competent and able to assist, Judge.
Ms. Ramirez, since the last time you were before me, has another judge like me declared you mentally incompetent?
Oh, excuse me, sir. I'm so sorry.
Yes. Has another judge like me, as the last time you were before me, has another judge like me declared you mentally incompetent?
Oh, no, Your Honor.
All right. Have you had an opportunity to go over the state's motion to revoke your probated sentence with your attorney, Mr. De La Garza?
I'm sorry, sir. I didn't. Can you read?
Had an opportunity to go over the allegations contained in the state's motion to revoke your probated sentence with Mr. De La Garza?
Yes, Your Honor. I'm sorry. Yes, sir.
After having done so, do you understand what the allegations are?
Yes, Your Honor.
All right. When I ask you now, how do you wish to plead to the state's motion to revoke your probation? Are the allegations contained in the state's motion true or not true?
Judge, there's a lot of things that I'd like to let you understand that when we discussed this, there was different time lapses within and she understands them. But, you know, a lot of the things that were being alleged happened and were heard at a different motion to revoke before I was attorney. And that's why it's kind of the way the progress report reads is a little bit, it was difficult to get.
Well, we can cure that, Mr. Lagarza, by telling me what does she plead true to not or not true, and we can take it from there.
Well, she is the same person, of course, that is on your probation, which she does say. She does understand that I think the thing that gets us is the part where she has been modified on certain occasions and has gone off to safety. She was unsuccessfully discharged because of what occurred on September the 9th, 2021. And I guess that's where we kind of started, because she's been on probation for nearly a term of 10 years. And in that time, she's had a lot of relapses. That's, you know, she's not going to sit here and say that's not true. We've had this discussion. She knows that her shortcomings do involve her testing positive again after she's been tested with probation. So to all allegations where she's been tested, their numbers, what it is that are blood alcohol, she cannot deny that, Judge. We're not here to do that. And so on those issues, we cannot deny that, and she would be pleading true to those, Judge. I think our biggest concern here is that she's done as much as she can, and she wants to recognize the fact that she does need that help. It's just been a very tumultuous last 9.5 years. She did do, and I look back, you know, to kind of look at this and have it from a wide angle lens to see everything versus just what has happened recently. 7 years, the first 7 years were good. She did well for the first 7 years. It was not until late 2019 when I believe the problems began for her. That's when she, of course, did have to go and get more intensive counseling. She went to safety in 2020. She was released in 2021 of September. And then what happened in September, of course, she relapsed. And that's why we are here today, because when she showed up to the probation office on September the 9th, 2021, and then again, there was a home visit a month or 2 months after in November, she also wasn't doing well. She had a relapse. That's why she's sitting here and has been sitting in jail since December, Judge. And so,
well, here's the problem is that she has not really availed herself of what the program she's in. She's just there to say, I attended it. You got to remember this, Mr. Lagarza. In fact, in spite of the pleas of her excuse of continuously being relapsing, the court has to be aware also that there's a community safety issue involved here, and she doesn't seem to understand that.
We understand, Judge.
You may, but I don't think she from I cannot leave her out in the free world until I find some modicum, some evidence of her compliance and to show me that she's changed her life and that she's no longer that threat to the community. And we're here because she continues to be a threat to the community on all those relapses and drinking. It's a short distance away from being at home drinking, getting into a car and causing a disaster of ruining somebody's life or herself. That court can tell you in open court, it's a big concern. It causes me to not sleep well. And that's why when I take this extraordinary measure, I've given them an opportunity to see for what it is and to try to do something about it with their own constitution, their own God-given constitution. Stop. To take another track. It is a difficult endeavor. It is a dark road. With enough kicking at it, she can come out. I have seen very little effort on her part to kick and scream at the darkness for it to bleed daylight. She continues to find it so easy to stay in the darkness. I don't understand why. That's beyond my realm of knowledge. I
Judge,
understand what drives it, because that is within the realm of knowledge.
as far as I can tell, like I said, she did do very well for the first 7 years. She did complete a lot of the programs. She did do the community service.
I've read the report, Mr. Velez, and I see that. And that's why it's even more amazing to me because of that. I have read the report. I've seen that she has attended. I've seen that.
And she,
That's under constant supervision. And the moment that is taken away from her, she fails again.
and I think that's part of the illness for her. Obviously,
She's begging and praying now, but I wish she would do that before she does this drinking again and understand that she's causing her own demise by being untrustworthy. Untrustworthy. So there's only one solution I know for that she needs to go see what her eventual life is going to look like for a while. Because I don't think she'll otherwise understand the enormity, the grave sense of the situation for me as a judge. I have tried to work with her, much to the chagrin of some of my probation officers that don't agree with me. But I've tried. And I'm always hoping that those people that I tried, that some of the probation officers don't agree with me, will make me die and say, the judge was right. I did straighten my life out. I did take advantage of that opportunity. I am no longer drinking. I'm reporting. I'm doing everything straight by the book. That would be a wonderful, wonderful, wonderful result for me because it worked. But I can't do that by myself now, can I? I don't have that capacity. I have to rely and depend on them to do the right thing. This system is totally reliant on their conduct. And they find it so easy because for whatever reason. So I think it's time for her to go see something else that for her life is taking her.
and Judge, if she may speak, I know that we talked, the last time I visited her was about a week ago on the 7th. And we did discuss some things, and I believe she did want to go ahead and say some stuff on her own behalf. Ma'am?
I will give her the opportunity, but you tell me if she wants to be true or not true to any of the allegations here. I need that before we get to that part of listening to her as to what is it would be better placed her testimony until I do all of this, because at that point it's what am I going to do with her punishment?
And like I said, it was right around the middle of what I was saying is we're not running away from what is being alleged. Again, because of the fact that she does have those positives, there's no denying that, Judge. So we would be true to that because we don't.
Positive in the lying when she's caught, no, that's not my beer. No, I wasn't drinking that. I don't even like Bud Light. And then, she goes to the bedroom. There's a big Bud Light that she admits that she's been drinking.
Exactly.
It's just a connivance, the untruthfulness, the lying that really undermines the whole foundation of what I'm doing here. I can't work with people that are going to be obviously untruthful, lying to the face of an officer. That's either a tremendous lack of respect or tremendous ignorance of the importance of the whole situation, or defiance, whatever you call it. That's pretty amazing to me, because she knows that that's her Achilles heel. She knows that alcohol is her Achilles heel.
Oh, she's very aware of that, Judge. It has been.
But she won't do anything on her own to do it, to arrest this problem. she's provided enough bad role modeling for her adult children who probably freaked out that she's been sitting in jail this long. But it doesn't matter to her as long as she gets out and gets another drink. And she'll swear up to me that she won't, as others have. And the moment they get out, they're right back for public intoxication, or that they found in violation because they were still drinking and they were trying to hide it. So I've seen it all already.
Can I speak?
I just don't know if anybody can add anything else to it. And she will beg to me and she will tell me she'll never do it again and that whatever, and that she found God included. I think I've had that said to me too. But God is out everywhere. God's not only in jail, and she's never looked for God outside to help her with this. Counseling can only do so much for you. If you're not a recipient, if you don't go in there with a frame of mind that you really are going to want to get exactly everything that counseling can offer you, do what they ask, read what they ask, immerse yourself in that. And if you smother that with a little willpower, a little desire to say, this is enough, I've had enough of these problems, I don't want any more, I want to change my life. If that doesn't come from inside of her, it will never happen. Because it's a much needed ingredient in a successful rehabilitation, successful road to recovery. It is. I want to. You gotta not succumb, not be at those weak moments. That's when you need to gather strength, whoever you were in the past before you went this, before you got into this problem. I have seen no evidence of that from her, because there has been no consequences to her, because I have been willing to work with her, because I've given her an opportunity to do right by this. So she figures that now with more tears and more supplication and more fearfulness and more I've changed, and ever since I've been here, I'll never do it. She figures that she'll get another shot at it. And I, for one, am out fresh out of shots, Mr. Lagas. I'm not doing this in a vacuum. I'm not doing this to be rough, but I think this is what I got elected for, to enforce the laws and to provide for safety of the community if the defendant is no longer willing to participate in that endeavor and continues to ignore it and continues to violate it and continues to indulge in the prohibited conduct. That's where we're at. So what is it that she's going to plead true to, if anything?
Judge, she would plead true to the allegation that on September the 9th, she wasn't for a test and she did fail that test, Judge.
Which one?
September the 9th and November the 30th, the allegations that she did.
That's positive for alcohol.
Because those are true, Judge.
All right.
But if she wants to speak.
Does she understand that?
Yes, Your Honor.
All right, so I'm going to ask you. On the allegations contained
Sorry, Judge, I can't hear you, Judge. I can't hear. All I hear is Scotty Salas in the background. If you could speak up just a little bit, please. Judge.
Hey, are you by yourself in there, ma'am?
Me?
Yes.
Yes.
Aside from the officer, are you by yourself?
To the officer.
No, aside from the officer, are you okay? Remove,
yes, sir.
When the officer retreats back to where he was, remove your mask.
Oh, for you can take off. Okay.
All right, we can't hear you.
Okay.
So I was asking you if you had an opportunity to go over the allegations contained in the state's motion to revoke your probated sentence. You recall that?
Yes, Your Honor.
All right. And your counsel has clarified for me that you are willing to plead true to the allegation that on September 9, 2021, you tested positive for alcohol in the amount of 0.265 and 0.249 alcohol content. Is that true or not true?
No, yes, Your Honor. Yes,
Okay. And they're also saying that you are pleading true to the allegation on November 30th, 2021. You tested again positive for alcohol in the amount of 2.49 and 270 reading of alcohol content in your blood system. Is that true or not true?
no, yes, Your Honor.
Okay.
That is true.
All right. We'll mark the other ones as denied unless you're telling me you're going to plead to another one, Mr. De La Garza.
Judge, I believe those are the two that secure the fact that relapse, Judge, and that's what she knows she did.
Yes.
Smart Council Probation, Ms. Garcia. The
Good morning, Your Honor.
Smart Start is the one that's installed in the car?
Well, she told me that she couldn't afford the interlock, so she got the in-home device. So she was skipping tests. Towards the end, she was skipping tests and she was able to get behind the car and drive. Because she had just gotten out of safety. She was not employed. So I told her she had to get back on the monitor device. So she was able to get the in-home.
What evidence do you have that she was driving? I don't see nothing in your report. I see the condition that she's not to operate a motor vehicle, but the other ones are all.
I didn't put in my report, Your Honor, but I did receive a call from her husband, Daniel Garza, that she was driving and that she would also take her grandson with her and she was putting him in danger. So when the MTR was filed, Your Honor, I had to move quickly. I was, afraid that she was going to hurt somebody, especially during the holidays, Your Honor.
Is that the instance where she was she arrested for public intoxication?
That was the first motion, Your Honor. That was the first state's motion to revoke that was filed. She had 2 PIs, actually.
All right. Based on your plea to those 2 allegations, Ms. Ramirez, are you aware that in your plea of true to those 2 allegations, in all reasonable probability, I will find the allegations of the state's motion to revoke to be true as far as those 2 are concerned, and in all reasonable probability, your community supervision will be revoked. Are you aware of that?
Yes, Your Honor.
Are you pleading true to those 2 allegations contained in the state's motion to revoke because those 2 allegations are true and for no other reason?
On those 2 allegations, Your Honor, for the public intoxications, one of them was in 2017. I do plead guilty to that.
No, wait a minute. Let's go back.
Oh.
Right now, I asked you about 2 specific instances and you said that they're both true, right? When I asked you that, you remember that?
Yes, sir.
I'm talking about those 2. Are you pleading true to those 2 allegations? You told me that they're true. Are you pleading true because they are in fact true and for no other reason?
On which ones, Your Honor? Because I have not been arrested for a public intoxication.
No, ma'am. I only read you 2 of them. On November, is it true that September 9, 2021, you tested positive for alcohol in the amount of 0.265 and 0.249 alcohol content in your blood system? And you
yes. Yes, Your Honor. I'm not going to lie to you. Yes.
And then I asked you about the next one. Is it true that on November 30th, 2021, you tested positive for alcohol content in your blood in the amount of 0.249 and 2.70? And what did you tell me that?
Yes, Your Honor.
They're true.
I'm not going to deny. Yes, Your Honor.
All right. So this question is going to those 2. So are you aware? Are you pleading true to those 2 allegations we just talked about again because they're in fact true and for no other reason?
No, yes, Your Honor. They are not, yes.
Has anyone threatened you, promised you anything, or placed you under any fear of any kind to force you to enter a plea of true before me today?
No, Your Honor. Nobody.
Do you understand that by pleading true to those 2 allegations, you're giving up your constitutional right to confront the witnesses, the right to have them appear in person, and the right to have your attorney cross-examine him. Are you aware of that?
Yes, Your Honor.
All right. Now, I'll hear from her, Mr. De La Garza, at this point.
Okay. Ms. Juarez, go ahead and address the court.
Okay, ma'am, I'm about to assess your punishment. I need to hear from you. What do you want me to take into consideration?
Okay, well, Mr. De La Garza, first off, I would just like to apologize to you, Mr. Mayaganes. I'm sorry, Mr. Mayaganes. I would like to apologize to you for the mistake that I made. I'm not denying anything, and I am just letting you know that I do have a disease. I have a sickness. I understand that it's pretty much serious, and I'm not trying to like come up to you and cry about it and say this and that. But I mean, at this moment, I know I did my safe P time and I completed everything I was supposed to. When I was in my safe P, I was an AA facilitator. When I went to the halfway house, I was also an AA facilitator. Why I couldn't take my own advice when I came out, I have no idea. I'm not going to deny, and tell you that, it's a sickness. I've been sober before for 7 years. I mean, I've done it, and right now I'm sitting in here, like I've been here 82 days, and I've had a lot of time to think. I've had a lot of family members pass away of the COVID before I went into safety, and then right before I came in here. And at this moment, my mom had open heart surgery in April when I was in safety. She's diabetic. And then to find out about almost a couple of weeks ago or so that she's developing dementia. The only ones that are there to help my mom is me and my brother. My brother works, and then I was working before I came in, which I still have my job, as we speak. All I want to do is just make things right. I'm not getting any younger. I'm 48 years old. I've been married for 24 years. I got 3 kids, and I'm going on my 7th grandkid in a couple of weeks. And I don't have none of my grandkids living with me. They do visit, every other weekend, or, they're growing already, so they don't spend too much time with me and my husband. I'm willing to get all the help that I can out there. Any counseling, any classes that are needed for me to do, I'm willing to do it.
I don't think that'll help you, man. Okay, is there anything else? I don't think none of that's gonna help you.
Well, Judge, if I
Because you're saying all the buzzwords, and you told me that before. I told you that there would be a point when I would run out of options for you, right? And we got to this point. I didn't want you to get me to this point. I have no more choice. I can't trust your word. I don't trust anything you told me. Because your conduct has shown otherwise. I just can't trust anything you tell me.
Okay, and I don't blame you for that. I really don't. I mean, I'm the only one to blame in this situation. I'm the one that put myself here, and now all I want to do is just try to make it right.
You'll have an opportunity to do that once you come out. Let's see how you do that, because if you don't do it once you come out, you'll find yourself right back in jail.
And I do not want to go to prison. I do not want to do time.
I know that, but I have no other choice. I've run out of options with you. All right. Mr. De La Garza.
Judge, my argument would be very much so that she receive a low-end sentence, close to minimum. She did try. If you read, like I said, we do a wide-angle lens on this.
I want to talk to you, Mr. De La Garza. Can you send me out to a breakout room with Mr. De La Garza?
Is Mr. De La Garza or Nathan too?
No, just her and Mr. De La Garza and me.
Okay, hold on.
Do we have
Okay, the room is open.
do we have Ms. Ponce on?
Ms. Ponce? the mother of Elisa Don Espinosa?
Your Honor, she's on her way from Los Fresnos. I spoke to her right
Oh,
after.
he's not on, Mr. Legas. He went to a breakout room.
No, and thank you. She should be getting here hopefully in the next 5, 10 minutes. I told her
Okay.
to come the way she was. So,
Okay.
thank you.
What happened?
I'm not sure, ma'am. I had
They're in a
to.
breakout. They're in a breakout room, Carrizales. The
Oh.
lawyer and the judge should be back shortly.
Yes, ma'am.
Oh, they're on a break?
No, they're,
County Jail, who do you have there, please?
I think that's Michael Smith City.
Is that your claim? Okay.
Yeah. Mr. Smith, is that you?
Nod your head, Mr. Smith.
I guess so.
County Jail. Is that Mr. Smith?
No, ma'am, we don't have Smith here yet.
No, 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 no. Not Carrizales, County Jail. County Jail. We have Mr. Smith.
This is number 11, Mendoza Garcia Carlos.
Okay.
We have Smith here, ma'am, and Carrizales.
You have Smith and Carrizales?
Yes.
Okay, thank you guys. You're muted, Judge.
All right. The court will take judicial notice of all documents and file in this case based on your plea of truth to those two conditions, Ms. Ramirez. Based on your plea of truth to those two conditions we went over, I find there is sufficient evidence to support the allegations. State's motion to revoke. I hereby find them to be true. I hereby assess your punishment as follows. It is the order, judgment, decree of this court that you be taken by the sheriff of this county, that you be transferred to the authorized representative, Institutional Division, Texas Department of Criminal Justice, where you shall be confined for a period of 4 years. The court, your sentence will commence this day. You will be given credit for any time you have served in jail with these charges, and also any time you have been confined in any other rehabilitative programs such as safety, PRTC, or anything like that. Anything else, Mr. De La Garza?
That would conclude my business on this particular matter, Judge. I have one more issue or one more case.
All right, sir. Thank you.
Thank you.
All right, do we have, you have Carlos Alberto Mendoza.
He's on the screen. County Jail. Mr. Garcia, raise your right hand, please. Do you solemnly swear from the testimony it will be the truth, the whole truth, and nothing but the truth, so help you God?
Judge, he needs the interpreter.
Oh, the interpreter is not on. I think he's in another court. If Norma or Stella can call him.
Is the grandmother on and with Mr. Galazzo's case?
She's almost to his office, Judge.
Okay.
Cindy.
Yes.
Julieta's gonna come in and try to do it real quick before she goes back to Adolaki.
Okay. Yes. Okay. Want to tell the judge that?
Cindy, Cindy,
Yes,
the
sir.
camera's here.
Okay, thank you. Good morning, Julieta. Julieta, is it you on the Moto G Stylus 5G?
Yes, yes. I just wanted to let you know.
Okay, thank you.
Thank you.
Mr. Garcia, raise your right hand. Julieta, this is the one we need you for. Julieta,
Señor García, levante su mano derecha.
do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
Usted jura que el testimonio que está a punto de rendir va a ser la verdad, toda la verdad y nada más que la verdad, así lo hay de Dios, ¿lo jura usted?
Yes.
Yes.
Thank you. Put your hand down.
Gracias, puede bajar su mano.
All right, this is cause number 2019 DCR 659E. State of Texas versus Carlos Alberto Mendoza Garcia. Is that your true and correct name, sir?
Señor, su nombre correcto es Carlos Alberto Balboa García.
No, Mendoza Garcia.
Mendoza García.
Yes, sir.
Yes.
Okay. Are you the same Carlos Alberto Mendoza Garcia that were found guilty of possession of marijuana in the amount of less than 50 pounds or more, I mean, more than 50 pounds, but less than 2,000 pounds on April 30th, 2019?
Y usted es la misma persona que se declaró culpable del delito de posesión de marihuana, más de 50 libras, menos de 2,000 libras, el 30 de abril del 2019?
Yes, sir.
Yes, sir.
And at that time, you were assessed a 10-year penitentiary sentence, and it was suspended for 10 years, and you were placed on probation for 10 years. Do you recall that?
Y usted recuerda que en ese momento lo pusieron en 10 años en la penitenciaría, se suspendió eso y lo pusieron en libertad condicional por 10 años. ¿Usted recuerda eso?
Sir.
¿Cómo?
Sí.
Yes.
Okay. You're represented by Mr. De La Garza here this morning. Is that correct?
Usted lo representa el señor de la Garza esta mañana. ¿Es esto correcto?
Sí.
Yes.
Mr. De La Garza, you find Mr. Garcia competent and able to assist in all matters?
I do, Your Honor.
Amén.
Ahora le pregunta el juez al señor de la Garza que usted, si lo encuentra usted competente y que si usted lo pudo asistir a él en todos estos asuntos, a lo cual él responde que sí.
Okay. Since the last time you saw me, has another judge like me found you or declared you mentally incompetent?
Desde la última vez que usted estuvo conmigo, ¿algún otro juez lo ha encontrado a usted mentalmente incompetente, señor?
No, sir.
No, sir.
Okay. Have you had an opportunity to go over these allegations contained in the state's motion to revoke your probated sentence?
¿Y usted ha tenido la oportunidad de repasar estas alegaciones en el recurso del Estado, la moción para revocar su libertad condicional en la sentencia? Señor,
With your attorney?
¿usted ha tenido de repasar esto con su abogado?
Sir.
¿Cómo?
Sí.
Yes.
Did you understand the allegations?
¿Y usted entendió las alegaciones?
Sí.
Yes.
Okay. Now I'm going to ask you, how do you wish to plead to the
Ahora-
allegations contained in the state's motion to revoke your probated sentence? Are the allegations contained in there true or not true?
Ahora le quiero preguntar, cómo se quiere declarar a estas alegaciones en la moción para revocar su libertad condicional. ¿Estas alegaciones son verdad o no son verdad?
Sí, son verdad.
Yes, they are true.
Are you aware that on your plea of true to these allegations, in all reasonable probability, I will find the allegations in the state's motion to revoke to be true, and in all reasonable probability, your community supervision will be revoked? Are you aware of that?
Usted sabe que al declararse usted verdad a todo esto, lo más probable es de que yo voy a encontrar todo esto verdad y que voy a revocar su libertad condicional. ¿Usted está al tanto de esto?
Yes, sir.
Yes, sir.
Are you pleading true because the allegations contained in the state's motion are true and for no other reason?
Usted se declara verdad porque las alegaciones contenidas en las mociones del Estado son verdad y por ninguna otra razón, porque son verdad.
Sí.
Yes.
Has anyone threatened you, promised you anything, or placed you under any fear of any kind to force you to enter a plea of true before me today?
¿Y usted ha tenido alguna amenaza, alguna promesa o ha tenido usted algún temor y por esa razón usted se está declarando verdad hoy?
No, no, sir.
No, sir.
Okay. Do you understand that by pleading true, you're giving up your constitutional right to confront the witnesses, the right to have them appear in person, and the right to have your attorney cross-examine them? Are you aware of that?
Y usted sabe que a usted, al declararse verdad, usted está renunciando a algunos derechos constitucionales, como el de tener un confrontamiento con los testigos, también a que estos aparezcan en la corte y que su abogado los contrainterrogue. ¿Usted sabe esto? ¿Que está renunciando a estos derechos?
Sí.
Yes.
All right. Is there a plea agreement in this case?
Ahora pregunto al juez si hay algún acuerdo o convenio en este caso.
No, Judge, there's not. Obviously, in speaking with my client and going over this, he understands that the one condition he was told not to do, he did. That's returning to the United States illegally. And so the only thing that we would ask, because he understands that this will be a case for which he will be revoked and sentenced. And so in speaking with him, we're asking for consideration of a sentence that is low from the scale that he is on. He's been in custody since December the 30th of 2020. He was actually taken to with the feds. He was sentenced in an illegal reentry case in cause number 1:21 CR 48. And he was then remanded after serving his sentence of apparently it was about 5 months, because he was released on the 26th or 27th of May of 21 of last year to the custody of Cameron County for the motion to revoke. And so he's been in custody now since December. It's already been over a year, about a year and let's say almost 2 months since his arrest, dating back to December the 30th of 2020.
How much time did he get in with the federal?
He was given time served, so they're not telling me precisely. I looked on Pacer. It just says that he was arrested on the 30th of December of 2020, and he was sentenced to time served on the 26th of May 26th of 2021. So it's just shy of a 5-month sentence, which would be roughly about 150 days.
All right. The court will take judicial notice of all documents and filed based on your plea of true. I find there is sufficient evidence to support the allegations in the state's motion. I hereby find them to be true.
Dice el juez que va a tomar notificación de todo.
You're muted, Julieta.
Lo que dijo su abogado es de que usted volvió a ser arrestado con la custodia federal y que está pidiendo una consideración y que usted entiende que lo han revocado y que lo pusieron aquí por entrar ilegalmente a los Estados Unidos. Los federales le dieron el caso, uno de los casos que usted hizo y que lo dejaron libre el 27 de mayo del 2021 y permaneció ahí y le dieron tiempo por el tiempo que ya purgó en la cárcel, en la Corte Federal.
Sí.
Yes.
All right.
I think He wanted to speak
Therefore,
on
it
his
is
own
the
behalf.
order,
Just
judgment, and decree of this court that you be taken by the sheriff of this county. You be transferred to the authorized representative, Ministerial Division, Texas Department of Criminal Justice, where you shall be confined for a period of 3 years. Your sentence will commence this day. You will be given credit for any time you spent on jail on this charge. Thank you.
Ahora, señor, se lo van a llevar ahora a la penitenciaría donde el juez está ordenando que haga 3 años y que le den crédito por todo el tiempo que ya purgó, se lo llevan hoy. Gracias.
All right, Mr. La Garza,
yes, Judge. I think that would conclude my business for the court.
anything else?
Nothing further, Judge.
All right, have a good day, sir.
Thank you, Judge. You too.
All right. All right,
Are we going back to Ms. Espinosa?
yeah.
Carisalas, can we have Ms. Espinosa on the screen, please?
Yes.
Thank you so much. Do I need to swear her in, Judge?
What's that?
You want me to swear her in or not?
No, not really. But if you want to testify, I'll swear in at that time.
Okay. Mr. Galarza?
Well, the one looking that guy? Oh. That was not looking at dude. He told me to try to take, he told me like, previous permits I can try it, so I used, which I. Equals to.
Do I have, Ms. Ponce, I mean, Ms. Espinosa's, 2021-2450, the driving while intoxicated? Ms. Solis,
I put the
I have 2 files here.
the folder is there.
Oh, no, wait a minute. Stop it a second. I got him. All right. All right, I'm straight now. Okay. This is cause number 19 DCR 1951, cause number 2019 DCR 905, and cause number 2021 DCR 2450, all of them, the state of Texas versus Don Espinosa. Is that your current correct name?
Yes, Your Honor.
All right. Mrs. Espinosa, your grandmother is here. I asked her to be here because she sent me and I read a letter that she addressed to me on your behalf. And after reading it, I have one question for you. Why are you letting a whole bunch of people down? including myself. Why? Take off your mask. I need to understand with your background, as your grandmother or has explained to me. I understand. I want to understand with that type of background, why do you continue to engage in this course of conduct? Why?
I just made mistakes, Your Honor.
Well, how old are you, Mrs. Espinosa?
I'm 37.
You see, Mrs. Espinosa, if you were somebody between the ages of 18 and 24, I would agree with you. It's a mistake. But one supposes that physically and scientifically, by that your age, your brain has developed as much as it's going to develop. And along with that growth comes judgment. You have all kinds of judgment now. And so it's no longer a mistake. A mistake is when you have no judgment. You have been full of judgment for quite a while, ever since you've been violating the law. You have had judgment. So it's not a mistake when you do these things. You intend to engage in this conduct regardless of the consequences. You know within your own intelligence that when you get in a car and you've been drinking, you know that's not good. That is the wrong thing to do. You know that.
Yes, sir.
But you engage in playing Russian roulette with a gun, hoping that it's not loaded when it goes off. And so far, it's gone off on you 3 times. How many more times does it need to go off on you, Mrs. Espinosa?
I failed to take
Listen.
care of my responsibility to stay on my medication.
Oh, I disagree with that too. I will tell you right now, I am with your grandmother when she says that you're to be admired for a tremendous amount of effort that you put into your life, try to get ahead, to raise children, to have all those situations lay on you and you handled them. And you were successful at that. So that's to be admired. But the question remains, what happened with a person that showed such tremendous responsibility to do everything that you have done up to your life right now, except this? What happened? What's going on? What's wrong? Your grandmother has offered me a litany of individuals that believe in you, including herself. She's offered me glowing and tremendous recommendations about you. But I know that your grandmother, as she is president, I wanted her to be president so she can hear me out. Because I know that in bleeding through those words that she wrote me, it's a lot of pain. It's a lot of pain that is coming from somewhere, and you know where. Because when one loves dearly, when one loves unconditionally, it causes them tremendous pain to see that person they love that way hurting and in trouble. I brought you back because I intend to probate you again. But I will tell you in front of your grandmother here that I have a responsibility to the community. My job is not to give you chances and chances all the time. I have done more than enough with this effort that I'm going to make to restore you back to your family, back to your children, back to your community, back to your life. I'm willing to do that. But you have to be clear about one thing. I will not ever give you another opportunity again. Do you understand that?
Yes, Your Honor.
In other words, you're at the last hurrah, Mrs. Espinosa.
Yes, Your Honor.
I'm giving you back your life. I'm giving you back your fate in your own hands. Whether you choose to remain outside and live a life that your grandmother would like you to live is up to you and how you behave from here on in.
Yes, sir.
I apologize. I kept saying grandmother, your mother.
Mother.
Yeah, I'm
Yes.
sorry. Thank you for not correcting me. I knew I was committing a big way. Well, wait a minute. I need to. What's your no? It was your mother.
No, I'm getting old, but.
Well, you know, I used to have a black mustache, man. When
Yes.
I got into this job. Now look at me. But what is your name, Miss Yor, right?
Sheila Yor.
Yes, Miss Yor. Thank you for writing this letter, Ms. Yor. I have taken it to heart. I have understood it. I have leaned on it to give her another opportunity.
Thank you
But
so much, Your
I
Honor.
hope that we are all on the same page with this, Ms. Yor. That if she comes back to me on another violation of alcohol or any other violation of law, I will have no choice but to send her to the penitentiary permanent. For
Totally
however long she
understand.
may have. I just want to make sure that we're clear about that.
Yes.
I don't cherish the notion of sending people to the penitentiary, and this morning has been chock full of people that have let me down. Because I've given them one opportunity after another opportunity to do right by their loved ones, to do right by themselves, to do right by me. The one that is holding out that opportunity for them to see me straighten out their lives. I cannot engage in opportunity after opportunity because community safety demands that I take action. Okay? Fair enough?
Very fair. Extremely fair.
So in cause number 2021 DCR 2440, the court, what does, do we have what the record is here on this?
Your Honor, on cause number 2021 DCR 2450, on that one, she still has not pled. Because that
What are we
case,
doing with that one?
Your Honor, we need to work it out because she has not pled on that one. She had already been sent to TDC, so we were not able to go ahead and arraign her and do everything. That two that she
So
was
the
sent to
driving while
TDC
intoxicating was the cherry on the ice cream sundae?
That's correct, Judge, because it was driving DWI with a child and possession of controlled substance.
How wrong was that, Mrs. Espinosa?
Excuse me?
How wrong was that?
Extremely wrong. Extremely.
You're putting a child in harm's way because of what? Not a good thing.
No.
Well, I'm gonna have to handle whatever I can control right now, which is cause number 2019 DCR 905 and 2019 DCR 951. What was the sentence that I gave Mr. Janice?
It was 5 years TDC, Your Honor, for both.
What?
5 years TDC on both.
The court will suspend the imposition of said sentence and place you on probation for 5 years to run concurrent on each one of these cases. Under the following conditions. Mr. Cortez or Mr. Mendez, or who's handling this? Mr. Cortez. Is this your probationer, Mr. Martinez, Mr. Mendez?
Yes, sir.
Mr. Cortez, we're going to have to marry the conditions of probation because they involve two different offenses. One was evading arrest. No, I take it back. They're both evading arrest. Listen up, Mrs. Espinosa. These are the conditions of probation. Unmute yourself.
Sorry about that.
It's all right.
Defendant will remain arrest-free.
No more arrest, Mr. Espinosa. No more arrest. It doesn't matter to me whether you're guilty or not of whatever you're arrested for. Do you understand that?
Yes, sir.
Oh, it wasn't me. I was just watching what was going on and they arrested me too. It doesn't matter to me.
Yes, sir.
You have violated my conditions of probation by being arrested again, period. Do you understand that? Okay,
Yes, sir.
all right,
Alcohol and drug evaluation,
yes,
community service hours. I mean, excuse me, we're not gonna do that one because of the COVID, correct?
yeah. For right now, I'm not ordering any of that.
Okay. Restitution, if any, Your Honor?
If any, yes,
Maintain gainful employment,
yes,
GED or high school diploma, Your Honor, she doesn't have it.
do you have it? Yeah, she's a graduate of college, right, Mrs. Espinosa?
Yes, Your Honor.
Yeah, she's got it.
Awesome. And if I could just have a phone number from her.
I want a phone number, Ms. Yor or Mrs. Espinosa, where we are going to find you 24/7.
Yes, Your Honor.
What is it?
It'll be 956-908-0663.
Thank you.
All right.
Your Honor, and this is for both cost numbers, correct?
Right, they will run concurrent.
Thank you.
One fee for both cases.
Thank you, Your Honor.
All right, Mrs. Espinosa. I am doing this because you have another pending matter. But I want to ask you, in front of your mother, what has it been like to be incarcerated?
It's been the hardest thing, Your Honor, has been the fact that I'm not able to help my family and my mother. Just not being able to provide for them emotionally, financially, and sitting there and watching them suffer because of my consequence, having them suffer the consequences because of my actions has been the hardest thing that I've ever gone through.
Well, you have seen the reality of where you're going. I cannot, I did not want to show you a picture. I wanted to show you the reality.
Yes, sir.
That's why I sent you to the penitentiary to begin with, so that you could appreciate, so you could capture, so you could ingrain in your mind exactly what you're looking at if you continue on this road. Okay?
Yes, Your Honor.
All right. That'll be the order of the court. Thank you very much, Ms. York, for being here. Sorry about calling your grandmother.
For your consideration.
Guys, it wasn't personal.
I am a grandmother.
Okay, well, there you go. But you're her mother. You're
Yes.
Espinosa's mother. All right. Thank you for sending me the letter, man.
Thank you. In consideration.
What's that?
Are we resetting the new case?
Are you resetting the new case?
Your Honor, have we signed the arraignment?
I think I heard Mr. Gallardo say that he needs to deal with that, right?
Yes,
That's
he's
correct.
gotta get her arraigned and all that.
All right, well then reset it for arraignment.
We'll get the date from Norma, Judge.
Yes,
What's the
Thank
get?
you.
What?
he'll
We'll
get the
get the
date from me once he turns in his arraignment form.
That's
Yeah.
correct, Judge. Thank you.
All right, you're welcome.
Can we be excused?
Yes, sir. Have a good day. Thank you, Mr. Mendez.
Thank you, Your Honor.
Carrizales, can we have Mr. Smith, please?
Sir.
Those are announcements, aren't they?
Hi, can we have Mr. Smith, please? We're done with Ms. Espinosa.
Yes, ma'am.
Thank you so much.
Mr. Hinojosa turned in some plea papers for him, Judge, so we're gonna plea him out.
Okay, Mr. Michael Anthony Smith,
Yes, ma'am.
Did your attorney explain this paperwork to you?
Yes, ma'am.
Do you have any questions for your attorney?
No, ma'am.
Is this your signature for case number 2020 DCR 2314?
Yes, ma'am.
And is this your signature for case number 2020 DCR 2315?
Yes, ma'am.
Okay, thank you, sir.
Just gonna grab the file real quick. Check the criminal history.
No, ma'am, that is started. They were just saying if my writing was, if the signature was mine, and if I agreed to the terms or stuff like that. If they, how you call it? Like, if I understand what's going to happen, that's it.
That's it? So the judge hasn't talked to you yet?
No.
Yeah, but they said that they were.
Is that first dude, the one that's, oh, you know that guy.
Mr. Smith, can you raise your right hand, please? Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hand up.
All right.
I already swore him in.
This is cause number 2020 DCR 2315 State of Texas versus Michael Anthony Smith. Is that the true and correct name?
Yes, ma'am. Yes, sir.
This is also 2020 DCR 2314. Is that the true and correct name in that case?
Yes, sir.
Your attorney tells me, Mr. Smith, that you wish to enter a plea of guilty in both of these cases. Is that correct?
Yes, sir.
What are you telling me you're guilty of in both of these cases?
Can you repeat that, sir?
What's that? Take off your mask if you're the only one in there.
Can you repeat that, please?
What are you pleading guilty to?
Arson, second-degree felony, and attempting to disarm an officer.
All right. So you've already got that. One of them's a second-degree felony. That's the attempted arson in cause number 2020 DCR 2314. Do you understand that that calls for confinement in prison for a term of not more than 20 years or less than 2? In addition, I can impose a fine not to exceed $10,000. Are you aware of that?
Yes, sir.
With respect to the attempt to what what is that charge, Mr. Hinojosa?
The attempted to disarm the officers of the state jail, Your Honor.
Attempted disarm officers of the state jail in a jail facility. That is a state jail felony which calls for confinement in the state jail for a term of not more than 2 years or less than 180 days. In addition, I can impose a fine not to exceed $10,000. Are you aware of that?
Yes, sir.
That's in cause number 2020 DCR 2315. From here on in, Mr. Smith, I want to ask you questions that will apply to both of these cases. Do you understand that?
Yes, sir.
All right. Mr. Hinojosa, is there any need to rearrange Mr. Smith in either one of these cases?
No, Your Honor, we waive rearrangement on both cases.
Right. Mr. Smith, understanding in cause number 2020 DCR 2314, what you're pleading guilty to, which is the arson and the range of punishment. I'll now ask you in that case, what is your pleading the charges of second-degree arson? Guilty or not guilty?
Guilty, Your Honor.
Likewise, in cause number 2020 DCR 2315, understanding what you're pleading guilty, attempt to disarm a jail officer, state jail felony. What is your plea to that charge in 2020 DCR 2315? Guilty or not guilty?
Guilty, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
Are you pleading guilty because you're in fact guilty in both of these cases and for no other reason?
Yes, Your Honor.
Are you pleading guilty out of any persuasion of fear, hope of pardon, force, threats, or promises of any kind in both of these cases?
No, Your Honor.
Have you ever been in a mental hospital treated by a doctor for any mental disorders in both of
Yes,
these?
Your Honor.
What?
Yes.
For what, Mr. Smith?
attempted suicide, and bipolar schizophrenia.
And are you currently under treatment?
Yes, sir.
Are you taking any prescribed medications for your condition?
Yes, Your Honor.
Have you taken those medications this morning?
Yes, Your Honor.
Is there anything about you taking those medications that in any way prohibit or inhibit your ability to understand the proceedings this morning?
No, Your Honor.
You understand and completely acknowledge that you understand every single thing we've said so far. Is that correct?
Yes.
All right. Mr. Hinojosa, find Mr. Smith competent able to assist in the defense he may have in both of these cases?
Yes, Your Honor, I do. I've been Mr. Smith's attorney for a few months now. Met with him in the court's jury room when I was first appointed. I've taken numerous phone calls from him, both when he was at the Rio Grande State Center. Went to see him just yesterday. His condition from when he was at the Rio Grande State Center to now, Your Honor, is completely 180 changed. He was able to understand everything yesterday. He was able to assist me in his defense.
All right. Mr. Smith, there's a recommended sentence in both of your cases. Do you understand that?
Yes, sir.
Do you need to understand that the decision of whether to go along with his recommendation is only totally up to me? Do you understand that?
Yes, Your Honor.
If I, for some reason, after further discussion, decide that this is not an appropriate recommended sentence and I will not follow it, I will reject it.
Yes, sir.
If I reject it, Mr. Smith, I will allow you an opportunity to withdraw your plea of guilty in one or both of these cases.
Yes, Your Honor.
If I accept it, Mr. Smith, the way it's been stated, the way you understand in both of these cases, you may not appeal this case without your court's permission, except as to any pretrial motions Mr. Hinojosa may have filed on your behalf in both of these cases. Do you understand?
Yes, Your Honor.
In that case, I'm going to find as to both cases that your plea of guilt is freely and voluntarily made and you're competent to stand trial in both cases. I ask you to take it to this evidence to substantiate the plea in both cases.
This time, state offers exhibits 1, 2, and 3, cases respectfully.
No objections, Your Honor.
They'll be admitted. Mr. Smith, I have in my hand in cause number 2020 DCR 2314, what a packet of documents that is commonly referred to as a plea packet. These are all documents that are related to your case, to the arson case. And likewise, I have a plea packet for your attempt to take a firearm from a jail security officer in cause number 2020 DCR 2315. Both of these set of documents consist of 3 exhibits. I want to visit with you on exhibit number 1 to begin with. Exhibit number 1 in cause number 2020 DCR is a 8-page document, and on page 6, there's a signature line. There's a signature already on there. Is this in fact your signature, Mr. Smith?
Yes, Your Honor.
All right. Likewise, in cause number 2020 DCR 2315, your exhibit number 1 consists of 8 pages, and on page 6, there's a signature line. Is this your signature in that case?
Yes, Your Honor.
All right. Mr. Smith, when you signed these documents and you had them handed to me, you're in essence telling me that you were aware you were giving up, waiving certain constitutional rights. For example, you were giving up your right to a jury trial, your right to remain silent, not to incriminate yourself, and your right to confront your accusers in open court. Do you understand that?
Yes, Your Honor.
And is that what you want to do?
Yes, Your Honor.
All right. Further, Mr. Smith, with respect to exhibits 2 and 3 attached to each respective plea packet in each one of your cases, you are representing to me that you have an informal agreement with the state, the prosecutor, that those documents, exhibits 2 and 3 attached to your respective plea packets, are true and correct copies of the original arrest reports, lab reports, incident reports that were generated as a result of your arrest for arson and as a result of your arrest for attempting to take a firearm from a peace officer. Is that in fact your agreement? If they are correct copies?
Yes.
All right. Well, in that case, I'm going to find that you have voluntarily and intelligently waived your constitutional statutory rights, and the evidence offered by the state does substantiate your plea of guilt, and the court will find you guilty. What is Mr. Smith? I'm sure, does he have a background?
No, Judge. No convictions.
Is there any objection to me making this deferred?
And from Mr. Smith, Your Honor.
would object, Judge, but ultimately we defer to your discretion just because of the manner of the cases.
Well, help me out. What is your perspective?
Judge, I would just ask for, if this be the case, that we could amend the plea to a cold plea and that the court on its own do a deferred adjudication, if that'd be okay with the court.
How would we do that?
Essentially, we just change the plea papers to cold plea, and then you would assess deferred adjudication for this defendant.
And why is it that we do that? Why do we need to do that?
Judge, can we go to if you don't mind, a breakout room?
Yeah.
Hold on. Okay, the room is open. Muted, Judge.
I'm scratching it out the plea agreement where it says that. I want to put cold plea on both of them. Is that accurate, Mr. Dennis?
Is correct, Judge.
I will ask each one of you when I have an opportunity to come and initial the changes that I put on this.
Be right over after court, Judge.
All right. Mr. Smith.
Yes, Your Honor.
The court is going to modify the condition, the plea agreement. I'm going to allow Mr. Rosa an opportunity to explain to you what we're doing. so that you make sure that you're okay with this and you understand what's happening, okay?
Yes, sir.
Can you send Mr. Hinojosa and Mr. Smith to a breakout room?
Okay. Salas, can you join the breakout? Thank you.
Yes, Cindy.
Huh?
Did you call me?
No.
Oh, okay.
All right, we're back. Okay. In cause number 2020 DCR 2314, Smith, I am going to sentence you to 10 years deferred adjudication probation.
Yes, Your Honor.
And in cause number 2020 DCR 2315, I want to sentence you to 2 years deferred adjudication. In that case. Under the following conditions, Mr. Cortez. Listen up, Mr.
Yes, Your
Smith.
Honor. Defendant will remain arrest-free?
You are not to be arrested again, Mr. Smith, while you're on probation with me. Do you understand that?
Yes, Your Honor.
Alcohol and drug assessment?
Yes.
Random use?
Well, yeah. For the term of the first year, to see how he's doing. If he's not any problem, then you can eliminate him. What else?
Breathalyzer?
No.
Restitution, if any, Your Honor?
Yes.
Maintain gainful employment?
As best as possible, yes.
And GED or high school diploma?
Mr. Smith, did you graduate from high school?
No, Your Honor, but I have a GED, Your Honor.
All right.
And may we have a phone number for him?
Mr. Smith, I'm gonna give you, ask you for a phone number where we're gonna be able to find you 24/7. 24/7.
It's gonna be 956-266-7346.
Thank you.
I'll probably change it after a while.
Well, if you change it after a while, you have one important obligation: to give it to your probation officer.
Yes, Your Honor.
Because that's the only way they're gonna be able to find you.
Yes, Your Honor.
Now, here's another thing, Mr. Smith. Because of your relatively youth, I am going with deferred, hoping that you will take advantage of it and not come back to me during your probationary term. I will tell you right now that if you behave and give me 5 years at least of good probation without any more problems, I may let you go.
Yes, Your Honor.
And there's another thing that you at the end of the rainbow too, that at the end of your probation, if I shorten it to 5 years because you behaved absolutely wonderful, you may be the beneficiary of a finding of not guilty and all these charges being dismissed against you.
Yes, Your Honor.
But if you don't, you know what you're facing, Mr. Smith. You're facing a full range of punishment. Do you understand that?
Yes, Your Honor.
Now, what I'm gonna ask probation is to please refer him to the mental caseload, the mental probation caseload.
Yes, John.
Mr. Smith, you obviously are laboring under some tremendous mental situations. What makes you feel good is the medication. Do not leave them behind. Do not fail to take them. And if accordingly, if you have a problem with your medication, go back to where you got it and tell them what kind of problem you're having so that you can adjust, they can adjust it accordingly. Do you understand that?
Yes, Your Honor.
All right. Order the court. Anything else, Mr. Noza?
No, Your Honor, that'll be it if we're gonna be excused.
Oh, both probations to run concurrently, one probation.
Oh, that's true.
All right?
Thank you, Judge.
All righty. Have a good
Thank
day.
you, Your Honor. Have a great day.
All right.